Supreme Court heard arguments for a major abortion case today. The case that comes from Texas, where that state passed a law that effectively closed many abortion clinics by ramping up regulations for all providers. If the law were to stand, the entire state would have only a handful of providers clustered around major cities. And whatever happens could impact abortion rights everywhere. And there's a couple issues, Mark, that come out of this. First, the case itself. And some of the arguments, and I believe Justice Ginsburg laid in pretty well to the attorney, saying, wait a minute, you're saying it's okay to, talking about how imperative it is as a right, but you're willing to basically send people across the border to New Mexico to do this. The net consequence of this is, and for people, if you look at the map, you see how big the state of Texas is, people will be driving 300-400 miles in some cases to get to a clinic.
We talked about driving 200 miles. There's still 7 or 8 of them open. More could be built. But I don't think we're going to get to the merits of the case. I mean, this is, a case where you have a 4-4 court, unless Kennedy is peeled away. I read the argument transcript, or at least a major part of it. This went strictly along partisan lines. I could see them, and the first 15 minutes of the argument were devoted to maybe punting the case back to the trial court for more findings to kick this down the road.
And isn't that really going to be the big lesson from this, which is for people who say, you don't need 9. We haven't had 9 in the past. 4-4, especially with the ideological split, time after time.
The 9 with Scalia would have made it even more difficult for the challengers of the law. And if this splits 4-4, if there is a decision, this law stands.
Because in Texas.
Yeah, in Texas. And that would obviously be a template, perhaps, for other states that want to restrict it as well. I'm not taking a political side in it.
But there's a reason we had 9.
Well, there's a reason we had 9, and it seems to me it's a substantial challenge to the law. The reasons for enacting it, allegedly to protect women's health, seem palpably pretextual. They amassed a lot of evidence showing that, forcing these people into essentially self-abortions would actually hurt women's health. So
the bigger issue here really is that because of what Mitch McConnell has said, this is going to be a paralyzed Supreme Court. It's going to be deadlocked. As you said, this could go into 2017. And the result of that is that the president has a constitutional obligation to nominate a successor to Scalia. And you got the Republicans saying, we don't care. We're not going to even have any hearings on it. We're not going to do courtesy interviews. We're not going to do anything until after the next election. And that really doesn't serve the interests of the public.
It's going to be fascinating, at least from my end of the business, if people can articulate, assuming this comes down the way Mark did, and I think Mark's right, what a 4-4, a paralyzed court would mean, and how politics, when Article 2 clearly says it's the job of the president and then Congress got a job, doesn't mean they got to confirm the person.
No.
But they at least got to do the due diligence of doing the interviews and then give the person a hearing, and you would think an up and down vote.
Without a civics lecture and not taking either side in this, I've always thought that the most overlooked issue in elections is the president's power to nominate a Supreme Court justice, because it's such an important issue, but it doesn't seem to have that much traction with the public, because it's not that sexy.
I think it might this time. I know there's going to be attempts to make it one, certainly by Democrats.
Well, Cruz has already made it a huge issue, but it's not really working for him.
Now I want to get to the Apple story. Doug, we talked about this when you were out. Tech giant, of course, battling the FBI. Feds, they want the technology to unlock the Apple phone used by one of the San Bernardino shooters. Apple refusing to give it up. Basic question, which side do you fall on?
I mean, I think you have to. I don't understand how anybody at this point could trust the government when they're asking for you to give up your privacy rights. We see it time and time again.
Here comes
with
the
NSA.
tinfoil.
I mean, you say tinfoil, but everybody said, "Hey, I think the government's spying on everybody. You're crazy.
Well,
you're crazy,"
are.
and you found out they were.
Just because you're
and so now they're saying there's a safety issue. I don't understand how anybody at this point could say, "Yeah, willingly, here, take it and do the right thing." I just don't understand it.
Let me take the opposite view, which is Apple isn't doing this for altruistic reasons. They're doing this because they're looking out for Apple. They built encryption for the specific purpose here, not just to protect their users' rights here, but their own. Apple takes our data. We all have the products. They take our data for their own purposes, marketing and otherwise. Can't we have it where it's not like Comey went around this, right? He's gone. He said, here's my specific case. We got 10 cracks at opening this up. If we don't, we lose all the information forever. We're asking you, since you built the encryption, built it, in effect, the back door, if I want to use Apple's old terms, open it up. Can it be limited in scope?
Well, he's
Why does it have to be so broad?
Well, he's asking the legislature to have a debate on whether they can do this. That's what he's really
That's
asking
right.
for.
That's exactly
And
right.
so, if you agree, if you think they should, well then, that's where you're going to go. If you think they shouldn't, but there's going to be a debate now, and that's ultimately what you're talking about. And the debate wasn't had with the NSA. The debate was never had. That was something they did because they could do it on their own. And so now they're saying, well, we need you, and here's my argument. I don't understand how that argument can be made persuasively anymore. I just don't
Well,
understand
it's
it.
really
and just
Go ahead,
there
go
was
ahead.
another court ruling, even in the city right now,
Well,
that made it a little harder.
You have two different judges, one in the Central District of California where the San Bernardino case is. She ruled in favor of the government. And then you have an Eastern District judge who was a former assistant U.S. attorney in the Eastern District of New York who denied an application, but that was in a drug case. So, sort of like a slippery slope, because when you're talking about a terrorism case, okay, that sort of gets the public's ear. But you're talking about a run-of-the-mill drug case, and they want to do it then also. So I think what the Eastern District judge said was that he's not satisfied that the statute as
That's
written
right.
was met in this case.
We shall follow. Guys, great job tonight. Thank you so much. And thank you at home for joining us. We'll see you here tomorrow evening, 6 p.m. as always.